Hello everyone. It's Rosie again and welcome to my channel where we dive deeper into understanding homeowners associations, your covenant, or bylaws. In my first video, I talked about what HOA is, where it began and how big of an industry it has become. If you missed it, I suggest that you click on the link below and watch the very first episode before you continue with this one. It is my goal to make you understand what it has been like living in an HOA community or what to expect if you are thinking of putting an offer on a house that is within an association. I want to make sure that you have your eyes wide open and know exactly what you're getting into, so that you never regret your decision later on. I assume that if you're watching this video, that you have never read your covenant. Just like in my estimation, about 90% of homeowners living in an HOA community. If you have a paper copy of your CC&R or your bylaws, it will be helpful if you have it in front of you or download an electronic copy from your community's website. If you have it already, please turn to the page that has assessments printed on top because this is what we're going to talk about today. Assessment is the monthly or yearly association dues that you pay as a member of the association. It is also the term that is used for any additional dues that your association may collect, like special assessments, specific assessments, and capital improvement assessments, which we will all discuss later on. I know it is confusing, because to assess means to evaluate or to estimate. But this is the reason why I created this channel, so it becomes a little less frustrating for common people like us to understand this document, thrown to our faces when we bought our house that most of us never bothered to read. So try to keep up. Going back to the assessment page of the bylaws, you will see on the first paragraph, it indicates who is authorized to collect this sum of money, and how it's supposed to be appropriated. Then below that, about 3/4 of the page, it describes what happens if you refuse to pay or if you are delinquent on paying your dues. How your property can be levied, how much interest rate the association can charge, the penalty fees, attorney's fees, and other fines that the association can charge to penalize you if you do not pay your dues. Now, if there is one important thing that I wanted you to remember and cannot stress enough, is that there is no legally acceptable excuse for not paying your dues, and if you do not pay for any reason, it could result in you losing your house. As you may see, there is nothing in these 2 pages that specify any instances when a homeowner may be exempt to pay his or her assessments. If you have a dispute with your association, pay your dues first and then consult a lawyer to help you with your issue. Association dues are not like your telephone bill, where if you're not satisfied with the company that provides your line, you can stop paying them until they corrected whatever it is that has been bothering you, or the company will simply disconnect your services. If you do not pay your association dues even for a few months, or if you only have a yearly due and you missed paying for 1 year, expect that you will be in for a whole lot of trouble. Most commonly, new homeowners or homeowners who has not read or understood their covenant don't realize how harsh the rules are if you fail to pay your association dues. Some think that if they are not using the amenities of the community, that they have the option not to pay their assessments. This is not true. Let me say it again. It is not true. I hear a lot of homeowners get into trouble because of this. If you are a full-time member of the association, whether or not you step foot on any of the amenities that your neighborhood has to offer, you are required to pay your dues in full every single year, or every single month, whichever is applicable to your situation. If you are not in agreement with your association's board of directors and considering to boycott your association, or express your disappointment or displeasure by not paying your dues, do not do it. You are going to lose, no matter how legitimate you think your reason is. You are responsible and required to pay your dues no matter what, no exemptions. Well, actually there is one. And I'll discuss that later before the end of this episode so we don't jump from one subject to another, as confusing as it already is for most people. Now let me tell you a story that has happened in my subdivision a few years ago, about one of my neighbors who didn't know about the harsh penalties of not paying the association dues in time. He was delayed in paying because of financial hardships, but when he finally got the money to reconcile his account, he was told that his arrears were already turned over to a collection agency/law firm. And our association had already filed a lawsuit against him. Knowing that he was in the wrong, he tried to settle with our association, and in the settlement meeting after they agreed on the amount that he was supposed to pay to make the issue go away, They realized that the representative of the association who was at the meeting was not authorized to approve the terms of settlement that they agreed to, so they had to wait for hours to get the approval of whoever it was who can make the decision to complete the settlement. Of course, during this time of wait, as specified in our bylaws, he, as the delinquent homeowner, is responsible for paying all the legal fees of the association. So while they were sitting there doing nothing, the legal meter is ticking, not only for his legal representative but also for the associations. At the end, his total payment ended up costing him more than $7,000 for dues that was less than $500 per year, and the principal amount that he was supposed to pay was only for less than $2,000. If you are wondering if this is really allowed in your bylaws, here are the stipulations for your reference. If you didn't catch the last part of the stipulations, the order in which the payment is appropriated goes to the attorney's fees first, followed by the late charges that were imposed on your account, then the interest rates, the delinquent assessments, and finally, the current assessments. If you are not paying your account in full and you are paying just a portion, there is a possibility that your payments are only applied to the attorney's fees of your association and not principal amount. Out of the more than $7,000 that my neighbor paid, more than half of this money went to pay the association's lawyer. And later I will tell you a story of a woman not too far from our city, who thought that her account was made current until she realized that she was only paying a portion of the attorney's fees of her association. But it was too late and she got evicted from her own house. And while the stipulation says that the interest rate applied to your delinquent account could be at the highest rate permitted under the Act, there is no mention of how much this highest interest rate should be. There is also no cap mentioned on how much the association can fine you. So you as a homeowner could be easily taken advantage of. Some homeowners have been fined and paid more than $20,000 for unkept grass or broken mailboxes. Don't you think this is absurd and unreasonable? If you knew these rules beforehand, do you think you would still consider becoming a member of an association if you had a choice? You may be thinking, isn't the association represented by its board members part of your community? Aren't they supposed to serve the homeowners and look after what's good for the community, but above all its residents? Isn't this very unneighborly? This unfortunately is what some board members do to their neighbors. Some people don't understand that just because they could, doesn't mean they should. And if your association hired a community managing company, their take on this situation is nothing but part of their job. So you may want to talk to your association's representatives before they think about hiring a company to do what they volunteered for. Moral of the story? Make sure you allocate a budget for your association dues when you purchase your home, make it your priority, and make sure you are not delayed in paying it. Now let's continue with the assessment fees. In the first paragraph of the page about assessments, it specifies how the assessment fees are determined for both the full-time member and for an associate member. A full-time member is a member that has full access to all the common areas and amenities, so if your subdivision has recreational amenities, a full-time member has complete access to these facilities. Associate members' access is only limited to the common areas, and the dues is calculated mostly to contribute to the maintenance of these areas and the structure of the building if you live in a condo or a townhome. But an associate member is not allowed to use any of the recreational facilities. So an associate's member's assessment is usually half or less than a full-time member's assessment. Being an associate member is ideal for people who are not interested in using any of the amenities. In some communities, you can choose what kind of membership you want. Our association gave an opportunity to the homeowners to choose their type of membership when it was first formed. However, the amended bylaws now require that anyone who buys a house in our subdivision previously owned by an associate member, the property is automatically converted to full-time membership, so there is no more assessment difference whether or not the new owner has an interest in using the recreational facilities. Again, on the assessments page, there is a stipulation that talks about how dues or assessment fees are determined and the contributing factors considered when the association needs to increase it. This stipulation includes a mandate that if the dues are to be increased by more than 10%, It should be approved by the majority of the members. A majority is 51% of the total community's representatives. I say representative and not total residents because only one homeowner or one unit owner can represent a whole household with several family members all living in the same property. This stipulation favors the homeowners because it limits the power of the association to impose too large of an increase in dues, and if you look down on the same page where special assessments is written, it says that the association could charge a special assessment only if 2/3 of the eligible members voted to approve it. These are two of the very few stipulations in the standard bylaws that actually works for the home or unit owners. So what are special assessments? Special assessments are the unexpected expenses that all members, if approved, will have to contribute and pay in addition to the yearly or monthly dues billed to you. When do special assessments happen? Let's say, for example, the association through its board of directors, who has the full discretion of appropriating the association's funds, discovered that your clubhouse walls were infested with termites and for some odd reason, the insurance company is not covering the expenses because the condition was pre-existing.
I don't understand how it can become pre-existing if the association insured the structures as soon as it was formed as they should, and as suggested in the bylaws. If the clubhouse walls were left unchecked for years, it goes to show that the association board has been so busy nitpicking on other people's homes that they forgot to check what is supposed to be regularly inspected in the first place. But we're just telling stories here.
Let's say the cost of the repair expenses will deplete your association's reserved funds.
Reserved funds are at least 1 year's worth of assessments tucked away for emergencies, which associations under smart financial management should have. Especially if it is more than a decade old since it was first formed.
So instead of tapping into your association's savings, the board decided to levy a special assessment to all the homeowners. They will then call a special meeting to discuss the issue, and if the majority, or specifically, as it is written in the bylaws, 2/3 of the homeowners are in agreement to move forward, then a special assessment notice will be sent to all, and you are now obligated to pay it, whether or not you agreed. Take it from one of my neighbors who refused to pay a special assessment, and our association placed a lien on her house to collect the payment. When our association was first formed, a company that repairs cars was interested in buying a piece of land that is located at the front of our subdivision and owned by the developer. This piece of land was zoned commercial, but some homeowners were against having a car repair shop by the entrance of our subdivision. But before the sale of the property became final, this land was magically rezoned to a residential area, and the developer ended up filing a lawsuit against the city and our association for the disputable manner this piece of land was reclassified. Long story short, our association ended up buying the property and converted it to a parking lot. But because of the legal proceeding that they subjected our association to, the homeowners are not only dividing the cost of the land and its development, they also had to shoulder the expenses of all the legal fees incurred, including the attorney's fees, the fines that the city imposed, and the settlement payment for the landowner, and all the other expenses that the lawsuit created. And I say they, because at this time I wasn't a resident of the subdivision yet. This story was told by one of the lawyers I hired who uncovered the lawsuit and showed me all the documents. Now, I don't know how they were able to convince 2/3 of the homeowners to shoulder all these expenses, but my neighbor didn't agree. She didn't want to play a part in the dubious activities. This was her word. Of the board members of our association. But because of the special assessment stipulations, our association was authorized to put a lien on her house and collect the payment regardless of how reckless our board members acted. This is another proposal that I have been writing our lawmakers about. To pass a law that would require anyone who wants to volunteer and serve as a board member of an association to have some type of training or education and license before they could serve. Anyone else who is involved in real estate transactions is required to have a form of education and pass an exam to earn their license, but the people who are accountable for appropriating hundreds and thousands of dollars in dues and has a legal authority to lien, foreclose, and even evict you from your home could be just about anyone from your neighborhood, regardless of their lack of experience, lack of leadership, budgeting, or any other skills needed to be a responsible and knowledgeable board of director. Now let's go back to that one exception that could excuse you for not paying dues that I mentioned at the beginning of this episode. In one of my conversation with a real estate lawyer about how feasible it is to dissolve an association here in Georgia, she mentioned that within 4 years after an association's formation, if the homeowners wanted to contest their membership, they can file a petition to the court and invoke to dissolve the association. If most of the homeowners cease paying their dues, it is a way to show the court that they are no longer in agreement to continue with their association. Now, there are 3 things to remember here. Number 1, I'm in Georgia, so the rule in your state or in your area might be different. Please check with a lawyer if this example applies to you. Number 2, this can only be done if your HOA is less than 4 years old, and Number 3, you need a majority of the homeowners to join the protest. When all of these 3 conditions are met, then you really have a point of argument, and you are more likely to convince the court that the homeowners in your neighborhood are in agreement to dissolve your association. You cannot be alone in boycotting to pay your association dues, and that is one of the biggest challenges. The way that the covenant is written, you will always need more than 50% of the residents, or in most cases, 2/3 of the residents to act with you. And if your community has more than 200 homes like mine, getting people to unify is a very big challenge, even though majority are in disagreement with how our association is managed. Now, I think I'll end this episode here, and I'll let you contemplate on all these information for a little while. I know that the stories I am sharing are a little traumatizing, and I want to assure you that all these stories are non-fiction. I may sound like I'm just here to talk down on homeowners associations, but let me remind you that even though most bylaws are written the same way, it is the people who implement the rules that make all the difference. And out of the 3 properties we own that are under an HOA, only 1 property is under the control of people who are determined to fully take advantage of a very one-sided set of rules that mostly benefits them, and not the homeowners. Again, proceed with caution when you're buying a home in an HOA community. Do your due diligence, take as much time you need to do your research, talk to the neighbors, talk to the board members if they are available, and ask questions. Everything you wanted to know about the community you're moving into. In our next episode, I will continue to discuss the other types of assessments and initiation fees. I will also compare 2 communities who adopted the same set of bylaws and how one makes the residents feel like they belong to the community and the other one makes the residents feel like they've made the biggest mistake of their life. If you are already living in an association community and you are having the same experience as I do, I urge you to reach out to your lawmakers and ask them to pass a law that will reform homeowners associations in our country. If you have anything to add, correct, or if you have any stories you would like us to share, please get in touch. I would love to hear from all of you. Post your messages below, and we'll figure out a way to communicate. And don't forget to click subscribe and like my channel so that you will be notified when the next episode is up. Until next time, stay safe and be well.